What changes a case is not the headline that flashes across a screen. It is the moment the court record acquires a fact that cannot be explained away. For years, this matter has existed in a space filled with argument, speculation, and noise. Claims were made, denials followed. Documents were discussed in abstract terms, but none of that altered the legal posture in a decisive way. That changed when a sealed record was unsealed. Not leaked, not summarized by commentators, formally entered into the public docket by court order. What emerged was sworn testimony, given under oath, now part of the official record. Not from a political adversary, not from an anonymous source, but from someone with direct, personal knowledge of the residents, the storage locations, and the internal boundaries that were deliberately drawn during compliance with a federal subpoena. This is not a story about relationships or personalities. It is a story about procedure. In federal investigations, compliance with a subpoena is not symbolic. It is literal. When a subpoena demands the production of materials, the response must include every location where responsive items could reasonably be found. That obligation extends to personal spaces, private offices, and restricted areas if documents are present there. The testimony now unsealed describes a location that was excluded. According to the record, there was a wall-mounted safe located inside a private office area, concealed behind a portrait. Access to this safe was restricted. The combination was not shared with staff. And most critically, the area was explicitly designated as off-limits to attorneys who were conducting the search required to certify compliance with the subpoena. That detail matters, because when attorneys certify to a court that all responsive documents have been returned, they do so based on the information provided by their client and the scope of the search they were permitted to conduct. If an area containing documents is intentionally withheld from that search, the certification becomes legally compromised. The testimony does not describe confusion. It does not describe oversight. It describes a boundary that excluded counsel, a boundary that concealed evidence, a boundary that existed while sworn representations were being made to the government. This is where the law becomes precise. Obstruction of justice is not established by possession alone. It requires two elements, an act and intent. The act can be concealment. The intent must be to impede or obstruct an investigation. The act here is the maintenance of documents inside a concealed safe that attorneys were told not to search. The intent is inferred from control, restriction, and timing. After the testimony identified the location, investigators executed a search warrant on the safe. This is not speculation. The inventory return is part of the court file. Inside the safe, agents recovered 47 documents, not personal effects, not memorabilia, documents bearing classification markings. The inventory lists multiple levels of classification, including materials subject to special access controls. These are not generic records. They are documents that require secure handling and explicit authorization. But the most consequential detail is not the number. It is the overlap. According to the filing, several of the documents recovered from the safe were specifically listed on a prior certification submitted to the government. That certification stated that those documents had already been returned following a diligent search. That creates a direct contradiction in the record. A sworn statement filed with the court says the documents are gone. A search warrant inventory says they were still present, locked in a concealed safe. This is where legal exposure escalates. When the government evaluates obstruction, it does not ask whether someone eventually returned documents. It asks whether the process was interfered with, whether the investigation was impeded, whether false assurances were provided. If lawyers are told an area is off limits, and that area contains documents responsive to a subpoena, the law does not treat that as passive retention. It treats it as active concealment. This is not a matter of interpretation. It is a matter of sequence. First, a subpoena is issued. Second, Counsel is told certain areas are excluded. Third, a certification is filed stating compliance is complete. Fourth, documents are later recovered from the excluded location. That sequence is what prosecutors analyze. Several statutes come into focus when evidence like this emerges. One concerns concealment of records in a federal investigation. The statute does not require destruction or alteration. Concealment alone is sufficient if done knowingly and with obstructive intent. Another involves false statements. A person does not need to personally sign a document to incur liability. Causing a false statement to be submitted to the government can satisfy the statute if the person knew the statement was false and understood it would be relied upon. A third concerns conspiracy. If more than one person assisted in restricting access, moving documents, or maintaining concealment, the law examines whether there was an agreement to obstruct the lawful function of a government agency. The unsealed testimony addresses control. The search inventory addresses possession. The certification addresses representation to the court. Together, they form a coherent evidentiary line. What happens next does not depend on public reaction. It depends on procedure. When prosecutors obtain new evidence of this magnitude, they do not simply amend charges unilaterally. They return to the grand jury. They present the testimony. They present the inventory. They present the contradiction between sworn filings and physical recovery. Witnesses may be recalled. Lawyers who sign certifications may be questioned about what they were told and what they were not permitted to search. The grand jury then evaluates whether probable cause exists to support additional charges. If it does, a superseding indictment is issued. This does not replace the existing case. It expands it. It incorporates the new evidence and alleges additional violations supported by that evidence. The timing of this process is often misunderstood. Federal criminal procedure does not move on a news cycle. It moves on documentation, authentication, and review. Weeks, not hours. There is also a contextual reality that cannot be ignored. This evidence emerges during a period of heightened political sensitivity. Defense counsel will argue that expanding charges during this period is prejudicial. Prosecutors will argue that their obligation is to charge crimes when evidence supports them, regardless of external calendars. Courts are tasked with resolving that tension. The Constitution does not exempt individuals from criminal process based on status. At the same time, it guarantees due process to every defendant, especially in unprecedented circumstances. The judiciary does not resolve that tension through rhetoric. It resolves it through motions, hearings, and rulings grounded in precedent. What remains clear is this: the court record now reflects sworn testimony identifying a concealed location, a search warrant inventory confirming classified documents were present there, and a prior certification stating those documents had already been returned. Those facts exist independently of interpretation. They do not require speculation. They do not rely on inference. They are fixed in the record. Grand jury proceedings remain sealed, but the procedural path is well established. Evidence is presented. Legal standards are applied. Votes are taken. Outside the courtroom, debate will continue. Inside the courtroom, the focus will remain narrow. Exhibit numbers, witness testimony, statutory elements. That is how federal cases are decided. Not by headlines, not by outrage, but by whether the evidence satisfies the law. The system promises two things simultaneously: that no one is above the law and that everyone is entitled to due process. Those principles are tested most severely in cases like this. The evidence now speaks. The process is designed to listen. What follows will unfold through filings, not commentary, through procedure, not performance. And that is where the case now stands.